Hello, my name is Steve Scardino, and I'm a partner at GEKLAW, and I practice workers' compensation and workers' compensation only. We represent injured workers in the California workers' compensation system employed by both private and public sectors. In this case, we're going to be talking about retirement issues for public employees, namely those in law enforcement and fire. The universal truth with public employees who are pursuing a medical retirement is that there's more involved than ever. Ever since March of 2023, when CalPERS issued their rather draconian memorandum about additional requirements, and frankly, always in the county system and previously state employees in the law enforcement realm were always required to get a special form completed by their treating doctor called a physician's report on disability. It's called something slightly different in CalPERS, but it's the same idea. It's a very short form, essentially a summary of your disability and how it affects your ability to do your job. Assuming you already have retirement grade limitations, as in cannot do, not should avoid. Should avoid is not good enough. That's called a prophylactic limitation, and you'll get caught in the purgatory between not able to work and not able to get your pension. It's extremely important that the treating doctor and all evaluating doctors going forward are crystal clear about inability to do the job, and that equals what I said before, a retirement grade limitation. Once your treating doctor is willing to complete the physician's report on disability, again required with all municipalities in California, all counties in the county system, and all state employees like correctional officers, that report goes along with the retirement application to the retirement system. But then what happens? Say you've used up all your sick time, you've been paid out 4850 time, otherwise known as IOD or IDL or salary continuation, and you're done getting paid temporary disability because the doctor released you. What now? As long as you've applied for a medical retirement, whatever system it is, the employer is generally going to be obligated to pay you Labor Code Section 4850.3 pay, which is designed to simulate a retirement pay, and that's half salary tax-free until your retirement system starts paying you. The only problem is if you lose your disability retirement case, you're going to have to pay that back. And so if you're 50 or more and otherwise able to retire because of age and service, you may decide to opt for that. I strongly recommend having a consult with an attorney about your retirement rights and options. It's critically important that all the language and all the medical reports are similar, that there's a virtual consensus about your inability to do the job, unless you're, of course, able to go back to work, in which case you go back to work, problem solved. But this gets technical, it's time consuming. It used to be simple, it's no longer simple. It's never been more important to consult with an expert about this particular process, which, as I mentioned before, is harder than ever. I wish you luck with your retirement claims, but please get some help with it. If you have any further questions about this topic or other issues concerning workers' compensation, employment, or personal injury, please feel free to call us at 213-739-7000 or submit an online inquiry to info@geklaw.com. And for more information about that and other topics, please visit www.geklaw.com.